Hello everyone, welcome to Strive Edge IS. In this series, we are dealing with the past 1 to 1.5 years of current affairs topics and their backgrounds. This series is going to provide you with detailed and crisp analysis done by the subject experts that will help you in your upcoming prelims 2025. So today is the fifth lecture of Polity. Let us begin. So yesterday we were talking about the CBI. Okay, so right now we are dealing with the constitutional, statutory, and executive bodies. So in today's subtopic, we have Niti Aayog. So why was it in news? Because there has been a reconstitution of Niti Aayog. So about the Niti Aayog, which is an abbreviation for National Institute for Transforming India. So it is a government think tank formed in 2015 via a resolution of the Union Cabinet, replacing the erstwhile Planning Commission. So it acts as a think tank, first of all, and it focuses on things like SDGs and everything. Plus, it also works for the cooperative federalism. So, what is the composition? The chairperson is the Prime Minister of India. Then the Niti Aayog has a governing council, which has the PM, CMs of all states and UTs with legislature, plus the lieutenant governors of other UTs, ex officio members, vice chairperson, full-time members, and special invitees. So, who are the ex officio members? They include 4 members of the Union Council of Ministers nominated by the PM. The special invitees are usually experts of certain subject matters. Then in the regional councils, it has a regional council also, the Niti Aayog, to address specific issues and contingencies impacting more than one state or region. And then the Niti Aayog has a CEO, who is appointed by the PM for a fixed tenure. And the CEO has the rank of the Secretary to the Government of India. So what is the mandate of Niti Aayog? It is to oversee the adoption and monitoring of SDGs in the country and to promote competitive and cooperative federalism among states. So what is this meaning of cooperative and competitive federalism? Cooperative is when India's, in Team India, involving all states to work towards a national development agenda. So all states, okay, for example, we have A, state B, state C, all of them are working towards India's goals together. Competitive federalism is it promotes healthy competition between among states through their transparent rankings. Like all these states are also competing with each other. Okay, but in a healthy way. So the Niti Aayog also has some sector-wise initiatives like Niti Forum for Northeast, then Sathi, Sustainable Action for Transforming. Such schemes also are done by Niti Aayog. Why is it important? It is important in terms of replacement with the Planning Commission. Okay, and these terms are also important from your prelims perspective. Okay, let us move on to the next topic. The Central Information Commission. So what is this? This is a statutory body under the Right to Information Act of 2005. Okay, to ensure greater access to the information to Indian citizens. So what is its functions? Its functions is to receive and inquire into complaints from any citizen regarding RTI Act. Okay, who are the members of this commission? Commission consists of one chief information commissioner and information commissioners. So they have one chief commissioner plus there are other information commissioners who should not exceed the number 10. So they are appointed by the president on the recommendation of a committee consisting of PM, leader of opposition in Lok Sabha, and union cabinet minister nominated by the PM. What is their tenure? They shall hold office for a period of 3 years. Okay, what is important over here? That it is a statutory body. It is under the RTI Act. Okay, what else becomes important, guys, is the right to freedom of speech and expression. Okay, with respect to this, also RTI Act versus the official Secrets Act. As to what comes under the RTI Act. Okay, let us move on to the next subtopic. The Social Audit Advisory Board. Why was it in news? Because the first meeting of the Social Audit Advisory Board was held. Okay, and it is kind of a first kind of a body in India. So what is meant by social audit? Social audit is a process of examination and assessment of a program / scheme. Okay, that is audit basically. But what makes it so special is that it is conducted with active involvement of people and comparing official records with actual ground reality. So people are a very crucial part of this audit. Okay, so your social audit is equal to accountability check by citizens. Okay, that's why it is important. So what are the key principles that guide the social audit? Is access to information, which is jankari, participation, which is bhagidari, and protection of citizens, suraksha. Okay, now social audit is not compulsory in every case, but it has been made mandated, like it is compulsory in certain acts like the MG Narega Act. Of 2005. So section 7 of this act, section 17 of this act makes social audit mandatory for works done under MG Narega. Okay, so this is a good approach by the government. Okay, suppose you could get a question like social audits are mandated under which act? MG Narega. Representation of People's Act, Companies Act, Societies Act. Okay, so your correct answer is MG Narega. Okay, so what else is important here? Performance audits, which is done by CAG. Okay, give a read to this also. The next subtopic is Law Commission of India. So Law Commission is a non-statutory body. Very important. It is under the Ministry of Law and Justice, under the Department of Legal Affairs. So what is the genesis of the law commission, before that, what is its function? So what it does, it reviews outdated laws, okay, and it recommends legal reforms, etc. So what is its genesis? First time law commission was established by the Charter Act of 1833 by Lord Macaulay. And Lord Macaulay was the first law member. Post independence, first law commission was constituted in 1955. Okay, since then 22 law commissions have been appointed, each within 3-year terms. Okay, so the recommendations of the law commission are non-binding in nature. What are some of the important recommendations of the law commission? Is the 170th report of law commission talked about simultaneous elections. Okay, and the 262nd report talked about the abolition of death penalty. What else is important over here, guys, from your prelims perspective is Article 13 and the scope of judicial review. Okay, so what is the function of law commission? Is it to make laws or review them or to give judgments? None. So anybody would like to answer this? Yes.
Review them.
Yes. Very good. Okay, so I hope this is clear. Next subtopic is the Niti for States platform. So the government has launched the Niti for State platform. What is it is that it is a comprehensive digital initiative designed to empower states and UTs in their pursuit of national development goals. So what is it? It is a centralized repository of valuable resources. Everything. It is multilingual. It is going to be available in 22 major Indian languages and 7 foreign languages. It is tailored for digital training. Okay, all of that. So suppose you get Niti for states functions. So what are its functions? Is it for federalism or interstate trade or centralization of governance, or is it direct benefit transfers? Yes. What is the main goal of Niti for states? Would you like to answer? Anyone?
Option C.
Centralization. No, it is fed. See, it is a centralized repository, but it is not centralization of governance. Okay, so it is basically federalism. All the states are coming together for a digital initiative to empower states in their pursuit of national development goals. Okay, so it is federalism. Right, we talked about cooperative federalism. Okay, in that case, it is centralized repository, like there will be one database with all practices, like best practices, data sets and everything. Let us move on to the next subtopic, National Investigation Agency, NIA. So NIA, what is its function? Its function is counter-terrorism law enforcement agency in our country. It is established under NIA Act of 2008. So it was established after the 26/11 attacks. Okay. It is headquartered at New Delhi and it operates under the Ministry of Home Affairs. Okay. What you can study next is UAPA. Also Article 355, which talks about the union's duty to protect states against insurgency. Okay. The next subtopic is Delimitation Commission. So what is delimitation? Delimitation is redrawing constituencies based on census. Parliamentary slash assembly. Okay, so for your general Lok Sabha elections and also your state legislative assembly elections. So redrawing of parliamentary assembly constituencies. Okay, and this is based on census. The Supreme Court ruled that the delimitation orders can be reviewed if found to be manifestly or arbitrary unconstitutional. That's why it wasn't news. So just now I told the functions of it. What is the key objective behind the ruling is that the ruling clarifies that while delimitation orders are generally final and binding, courts can intervene in exceptional cases of arbitrariness. So like we know that delimitation commission and its order cannot be called into question by any court. Okay, but recent judgment shows that if there is a question of constitutionalism or constitutionality, that time it can be asked. Okay, that time the courts can interfere. So this is a very important part. So what was the case behind this? It was the case pertaining to the Jammu and Kashmir's delimitation exercise, which had been challenged on constitutional grounds. So this particular case made it possible. Okay. So what is important here for a prelims? This fact, also the article 82, which says that Parliament enacts delimitation act after every census. With this, you can also read the RPA Act of 1951. Okay. 23rd Law Commission. So we saw that by now 22 law commissions were done. So the president has constituted the 23rd Law Commission from 2024, September 2024 to September 2027. So 3 years. We also learned its tenure. It was for 3 years. To recommend legal reforms and strengthen the legal system. So what is their mandate? What is their functions? Is that to review obsolete laws and propose repeals or amendments, examine laws impacting the poor, socio-economic legislation, suggest measures to improve and promote gender equality, all of this. Okay, now question for you. Law Commission is under which ministry? Ministry of Home Affairs, Ministry of Law and Justice, Ministry of Personnel, and Ministry of Parliamentary Affairs. Yes? Anyone would like to answer this?
Ministry of Law and Justice.
Yes, very good. Okay. Good. So with this, we have finished the constitutional, statutory, and executive bodies. The next topic for today is judiciary. So the tribunal first subtopic is tribunal system in India. So what was the origin of tribunal system? Swaran Singh Committee in 1976 noted that the high courts were burdened with service cases, by public servants. So the 42nd Amendment to the Constitution was passed, and Articles 323A and 323B were inserted. Okay, so tribunals are a brainchild of the Swaran Singh Committee. What else was done by the Swaran Singh Committee? Fundamental duties. Okay. So what about the tribunals? Tribunals are quasi-judicial bodies. What do you mean by quasi-judicial? They're semi-judicial. The objective may be to reduce the caseload of the judiciary or to bring in subject expertise for technical matters. Okay. So in 1976, they got the constitutional recognition via the Article 323A and 323B. So what is the difference between these two articles? The Article 323A has empowered the Parliament to constitute administrative tribunals, both at center and at state level. So only administrative tribunals are under the 323A for adjudication of matters related to recruitment and conditions of service of public servants. So why was this whole entire tribunal thing was brought into picture? Because the high courts were burdened with the cases by the public servants. So they made one special tribunal, one special act for the tribunals of public servants, which is Article 323A. Now, Article 323B, you can make tribunals for certain specified subjects, such as taxation. Suppose there is some issue with taxation or land reforms, for which Parliament or state legislature may constitute tribunals by enacting a law. Remember, guys, okay, here both central and state level, here also both Parliament and state legislature. So the formation of tribunals can be done via acts. Okay, and the acts can be done by both Parliament and the state legislative assembly. Okay, so it is not the whole entire responsibility of center. Basic difference is also understood, I hope. 323A is for administrative cases and 323B is for certain specific cases. Okay, such as taxation, land reforms. We have foreign tribunals, for example. So what is the composition of tribunals? Expert members, okay, technical members. For certain cases, we need certain expertise along with judicial members. That's why it is quasi-judicial, because there are judicial members plus there are some non-judicial members also. Then the jurisdiction. Each tribunal is given specific jurisdiction to hear and decide cases within its designated area of expertise. Appeals. What about the appeals? So appeals from tribunals usually lie with the concerned High Court. However, some laws that specify appeals will be heard by Supreme Court also, but directly they can appeal. Somebody, some tribunal has given some verdict and the concerned party is not okay with that, then they can appeal. They can appeal to the High Court. So in which case this was given? This was given in the Chandra Kumar case. That appeal against decisions of tribunals were allowed in the division bench of High Courts. Okay. So what is important here? These two articles. Who can constitute the tribunals? The Chandra Kumar case. Okay. Yes. We'll move on to the next subtopic. The National Legal Services Authority, NALSA. So what is this NALSA? It is established under the Legal Services Authorities Act of 1987, which oversees legal aid policies and activities across India. So what is its aim? Its aim is to provide free legal services to the poor and marginalized in India. So which article is this? This article is 39A of the DPSP. Okay. NALSA provides legal aid for cases in courts, tribunals, and other judicial bodies and promotes alternative dispute resolution. Okay, ADR. Central government allocates annual funds to NALSA, distributed to state and district legal authorities. State governments cover state level expenses, including salaries. So for NALSA, the central government gives, and for the state level, if you have the authority, then the state gives. So which weaker sections are covered under the section 12 of this NALSA is women and children, members of SCs, STs, industrial workmen, persons with disabilities, persons in custody, victims of human trafficking, all of this. Okay. So the NALSA grants authority to oversee, okay, to also oversees at national, state, and district level. These are the functions, like I said, for basically it is to give free legal aid for people who cannot afford. So what are the government initiatives for legal aid? We have Disha. Disha is designing innovative solutions for holistic access to justice in India. So these are also important. Make sure that you give a read to this. Then we have the Nyaya Bandhu platform, which facilitates connection between pro bono advocates and registered beneficiaries. Then we have the Telelaw service, which connects beneficiaries with lawyers via televideo conferencing. Then we have the Nyaya Mitra program, which facilitates disposal of 15-year-old pending cases at the district level. So what are the constitutional provisions regarding to, related to free legal aid is the Article 39A, which I already said, which is a DPSP, which mandates the state to ensure justice with equal opportunity, including free legal aid provision. Then Article 15, which is equality before the law for all individuals. Then Article 22(1), which provides protection to individuals arrested or detained, ensuring their right to legal consultation and representation. But all of the people cannot afford a lawyer. So that's why free legal aid. Okay. So question for you. Free legal aid is in which article? Article 21, Article 39A, Article 32, or Article 51A? Yes, anyone would like to answer?
Article 32, madam.
32 is writs, no? Okay, just now I said 39A is free legal aid, okay? Remember. I hope you'll never forget now. Okay. We'll move on to the next topic. Article 142, which Article 142 is, and it talks about the idea of complete justice. So what is the idea behind this complete justice? It means to ensure justice by filling the gaps in law and overriding legal provisions when necessary. So what is the basic function of judiciary? Judiciary's basic function is, deciding between giving judgments, basically. Okay, judgments. Then constitutionality of laws. But making rules or making laws is the work of the legislative, right? And executing them is the work of the executive. But sometimes what happens is that sometimes there are gaps in the law. So what judiciary does then, it overrides the legal provisions. So it overrides its only judicial power. It sometimes takes the power of executive plus legislative, okay, in order to make complete justice, okay, to fill it completely so that no gaps are left anymore. This was seen, for example, in the Vishakha guidelines. Okay, so there was a case, Bhavari Devi versus state of Rajasthan, in which there was a case about the sexual harassment at workplace. So what the government, what the Supreme Court did, it provided some guidelines. Okay, this is not the primary work of Supreme Court. Supreme Court's work is basically, judiciary's work is to decide, okay, to give judgment. This is correct or this is wrong. Only that. It cannot give guidelines, but it went ahead of its normal function and it gave guidelines on this. Then the POSH Act was, okay, it was kind of based on these guidelines. Okay, this is an example. So this is the entire idea behind Article 142. Why was this in news? Because again, in Bilkis Bano's case, the Supreme Court has invoked its power under Article 142. So the Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such order as is necessary for doing complete justice in any case or matter pending before it. Okay, so that is the basic idea. Okay, so now for you, what becomes important, guys, is judicial overreach versus judicial activism. Okay, key differences between these. Okay, suppose you get a question. What is the limitation of Article 142? Now we saw that, in order to make complete justice, the Supreme Court can do anything, but also it is limited to certain cases. So what is the key limitation? It can't be used for electoral disputes. It can't override constitutional provisions. It requires parliamentary approval. It is applicable only to civil cases. Yes? What do you think? What is the limitation on Article 142? It can't be used for electoral disputes? Yes, it can. Okay, because in order to do complete justice, suppose there is a dispute and the concerned authorities are not able to do anything, so the judiciary can interfere. Okay. It requires parliamentary approval. No, it does not. It is applicable only to civil cases. No, we see it happening in criminal cases as well. But it can't override constitutional provisions. Okay. So they are also bound by constitutionality. Okay. Let us move on to the next subtopic. 75 years of the Supreme Court. So the evolution of Supreme Court of India. First of all, in the Regulating Act of 1774, Supreme Court at Calcutta was established. Subsequently, Supreme Court of Madras in 1800 and Bombay in 1823 were established. Then secondly, we had India High Courts Act 1861. High courts for various provinces. And it abolished all the three Supreme Courts. Okay. Then the Government of India Act of 1935. The Landmark Act. It created a Federal Court of India. Okay, very important. And it hears appeals against judgments from High Court. So here the appeal system started. Can you please mute, dear, whoever it is? Okay. But the Supreme Court of India, it came into existence after 28th of January. So basically after the Constitution of India. Okay. So a glance at the relationship between the judiciary and executive. So Article 50 in Part 4, which is DPSP, okay, talks about the separation of power, separation of the judiciary from the executive in public service. Then 1947 to 1964, the confrontation began in the issues of right to property. So who is, higher? The executive is higher or the judiciary is higher? So this case, Kameshwar Singh versus State of Bihar, the government brought the first Constitutional Amendment Act and inserted the 9th schedule. So anything, any law, if it was put under 9th schedule, the court could no longer intervene. Okay. So basically what they did executive greater than judiciary. Then 1965 to 1993, due to frequent amendments to Constitution, the Supreme Court had to assert its position. And the Golaknath case and Keswananda Bharti case, landmark cases, it established the dominance of SC. Okay, established the dominance of Supreme Court. So basically, judiciary. What was given in this case? Basic structure. Okay, so again, the government then responded with the Constitutional Amendment Act of 24th and 25th, which again restricted the power of Supreme Court. Again, the Minerva Mills case asserted the position of Supreme Court. So this tussle between the executive and the judiciary was going on. Then finally, in the 1993 to 2018, this particular batch, something came as the 3 judges case. Okay, all those judges case, in which it had empowered the power of Supreme Court in the appointment of judges. Okay. Then again, NJAC was brought in, where again the executives were greater than the judiciary. But however, this NJAC legislation, okay, the 99th constitutional amendment, so this was struck down by the SC, calling it unconstitutional. Okay, so now for appointment of judges, we have something called as the collegium system. So these are certain important articles with regards to the Supreme Court. So Article 124(1) says that Supreme Court of India must have a CJI, Chief Justice of India, and maximum of 7 additional justices. So the constitutional provisions for the Supreme Court is from Article 124 to Article 147. So what are the key features of Supreme Court? It is the highest court of appeal. Okay. Then it has advisory jurisdiction. So as per Article 143, the Supreme Court can advise the president on legal matters of public importance. Then it can adjudicate on federal disputes. That is its original jurisdiction. Okay, according to Article 131. So federal disputes as in disputes between union and states. Then judicial review. The Supreme Court reviews laws and actions of the executive to ensure its compliance with the Constitution. Then protection of fundamental rights via Article 32. Then public interest litigation. The court can take up cases on its own on behalf of the PILs. Okay. So what about the regional benches? So the Supreme Court of India may invoke Article 130 of the Constitution for establishing its regional benches at 4 or 5 locations. So as per the Article 130, the Constitution of as per the Article 130, the Supreme Court shall sit in Delhi or such places as the Chief Justice of India may, with the approval of President, from time to time appoint. Okay, so right now it is at Delhi, but if they want a change, then the Chief Justice can make it happen with the approval of President. Okay, so one question for you guys. Before 1950, which institution was of the highest appellate? Okay, so before the Supreme Court of India, there was something called as the Privy Council. Okay, that was the institution of highest appellate. What becomes important, guys, over here is the writ jurisdiction of Supreme Court with respect to high courts also. Okay, then you can also study about the different kinds of jurisdictions like advisory, appellate, original, all of this. Okay, Supreme Court, this particular thing has been covered in the last lecture, guys, so you can just refer to that. I think there has been a misprint or something. Again, it has come in this topic also. Okay, next topic is foreigners tribunals. So like we discussed that tribunals can be established, right? I hope you remember. So by Article 323A, we can establish an administrative tribunal, and Article 323B, we can establish a tribunal for certain specific cases. So foreigners tribunal is one such example. Okay. So again, the establishment is, they are quasi-judicial bodies established under the Foreigner Tribunal Order 1964 by the central government according to the section of this particular act. Okay. So why was it in news? Because the NRC thing that is going on in Assam. So suppose if NRC has, it is a national register of citizens, right? So suppose it has all the names of people who are citizens, but if person A has been, that person is not written in NRC, so this person's name is omitted. Okay, so does he automatically become a foreigner? No. Okay, so the Supreme Court has said that only foreigners tribunals have the power to declare a person as foreigner. Okay, so this is important. So if, okay, being excluded from the NRC in Assam does not automatically classify a person as a foreigner. Okay, so this is important over here. So what are the powers of the foreigners tribunal? Powers of a civil court. under the CRPC Act. Okay, what else can you study here? The Citizenship Act, Assam Accord. Okay, also the NRC debate. Okay. Jumping on to the next topic, state of infrastructure in district court. So why was it news? Because a recent report by the Union Ministry of Law and Justice has highlighted critical gaps in infrastructure across the district courts in India. Like, what are the key findings of the report? That 37.7% of judicial officers lack adequate courtroom space, limited access to basic amenities such as drinking water, waiting areas, toilets, then shortage of trained human resources, okay, inconsistent implementation of e-courts projects. So basically, there is a huge gap. Okay. This is not that important for your prelims perspective, but you can just give it a read, guys. Okay, let us move on to the next topic, free legal aid. Okay, we just now discussed about the NALSA, right? So it is somewhat on the same basis. So because why was it in news? Because Supreme Court has directed stronger access to legal aid for prisoners. So what are the key measures by Supreme Court? That it has said that strengthen the legal services authorities, okay, and monitor prison legal aid clinics, raise awareness of legal services and digitize reporting systems. Again, what is the legal framework for this? We have Article 39A, which says equal justice and free legal aid. Also, this particular act, under which we have the NALSA also, right? Legal Services Authorities Act, which establishes NALSA, SLSA, and DLSA. So this is at the state level. This is at the district level. Okay, this is at national level. What other government initiatives are there? Disha, Telelaw, Nyaya Bandhu. Okay, we discussed all of this. Okay, let us move on to the next subtopic. Supreme Court questions feasibility of Gram Nayalayas. Okay, so Supreme Court has expressed concerns about implementing the Gram Nayalayas Act 2008 due to challenge in its feasibility. So what are the challenges? Like, there is ambiguity in establishment. The act's wording has may constitute. Okay, so this particular act has may constitute. So when you say something as may, it may be done. So that gives that it is discretionary for the states. Okay, so it does not, it is not mandated. If you want it to be mandatorily done, there should be shall constitute. Plus, there is a resource crunch. The states face financial and logistical constraints. There is also a rising burden. So appeals and writ petitions from Gram Nayalayas could overwhelm the higher courts. So what are the features of Gram Nyalaya, guys? They are mobile courts with civil and criminal jurisdiction. Very important. Okay. Mobile courts as in they are on the move. They are not, they are not situated at one place. They are on the move. Then they are located at the intermediate panchayat level or group of panchayats. Okay, and they promote conciliation based dispute resolution with assistance from social workers. So they're basically, their main function is to promote conciliation, to get if there is some kind of if you can reconcile again, okay, then they help in that way, okay, with the help of social workers. So what is the implementation status of this? So out of the targeted 2,500 gram nyalas, only 314 are operational. Because again, this, the act's wordings were may constitute. So that became discretionary. So not all states have done anything. Okay, states like Maharashtra and Madhya Pradesh have shown progress while others still lag behind. Okay, so what else is important for you guys here is the 73rd Amendment Act. Okay, PRI, also rural justice. Next subtopic is the 51st Chief Justice of India has sworn in. Justice Sanjeev Khanna was sworn in as the 51st Chief Justice of India in a ceremony at Rashtrapati Bhavan. So what is the role of CJI? He is the master of roster, as in he will assign the cases to benches, including the constitutional benches. Then he is the collegium head, leads the judicial collegium responsible for appointments and transfers. And he also ensures the smooth functioning of the Supreme Court and its administration. Okay, so the appointment of the Chief Justice of Supreme Court is done under the Article 124(2). Okay, what else you have to study is as the appointment, hence the removal process. Okay, also study about the collegium system. Next subtopic is e-courts mission mode, project phase 3. So according to this, what is the objective? To digitize all records for paperless judicial system, focusing on ease of justice. Okay, under which ministry? Department of Justice, Ministry of Law and Justice. Next subtopic is Supreme Court Legal Services Committee. A Supreme Court judge has been appointed as the chairman of the Supreme Court Legal Services Committee. Okay, so what is this? It is a statutory body constituted under the Legal Services Authorities Act of 1987. Very important. Okay, so what else was done under this? NALSA, the SLSA, also the DLSA. Okay, so what is its objective? Its objective is to provide free legal services to underprivileged and marginalized sections of the society at Supreme Court level. Okay, then the CJI, the Chief Justice of India, serves as the patron in chief for the SCLSC. Who are the members? The chairman is a sitting Supreme Court judge, and 9 other members nominated by the Chief Justice of India. Okay. So, which body provides free legal aid at the Supreme Court level? Is it the Bar Council? Is it the NALSA? Is it the Supreme Court Legal Services Committee? Or is it Ministry of Law and Justice? Yes? Anybody?
Option D, madam.
Yes. Option C, no?
Yes, yes, ma'am.
Yes. Okay. So what else you have to study here, guys? What else become important? All that we've been discussing, the NALSA and everything. Okay, Lok Adalats, all of that things. Next subtopic is the Supreme Court annuls remission in Bilkis Bano case. So why was it in news? Because the Supreme Court struck down the remission granted to 11 convicts in the Bilkis Bano gang rape and murder case, citing jurisdictional overreach by the Gujarat government. So the Gujarat government had given remission to the 11 convicts, okay, but Supreme Court has struck it down, calling it was jurisdictional overreach. So what are the key highlights? Gujarat was not the competent authority to decide the remission since the trial was conducted in Maharashtra. Okay, hence the remission orders were declared invalid. Okay, so what is the legal aspect of remission? Remission means reduction in sentence without altering the nature of punishment. Suppose a particular person has got punishment for 10 years. By remission, what the governor or the president will do, they will make it 5 years. Okay, so only the years as such, so there is only a reduction in the term, but the nature of punishment will be same. Okay, so who has the power of remission? Via article 72, it is president's power. And in what cases can the president give remission? It covers court martial cases, union law violations, and death penalties, death sentences also. Okay, via article 161, governor can also give remission, but only at state level cases. Okay, so CRPC also gives some remission provisions. So Supreme Court precedents on remission. So Supreme Court has given some mandatory, some criteria on deciding remission. So what are the 5 criteria given in the Lakshman Naskar versus Union of India case? Is that the impact of society, likelihood of repeat offenses, future criminal tendencies, whether further imprisonment serves a purpose, and socio-economic condition of the convict's family. So these 5 things also has to be taken into consideration. Okay, so basically, who has the power? Who has the constitutional power to grant remission? Okay, is it Supreme Court, Parliament, President, and Governor, or the Chief Justice of India? Yes? Do you like to answer? Anybody? Who can give?
President,
Yes, very good.
President Governor.
Yes, President and Governor can give remissions. Okay. So what else is important? As you might have guessed, all those things: pardon, remission, respite, commutation, all of those things. Okay. Pardon, remission, respite, commutation. Also studied with respect to the governor and president. Okay. Next topic is mercy petition. So what is a mercy petition? It is, it is a kind of plea for clemency. Clemency as in leniency. Okay. Filed by a convict sentenced to death / life imprisonment. Okay, so the president can, again same thing it is what we discussed earlier. President can grant mercy under article 72, and governor can grant mercy under article 161. Same thing. Okay, so there are different forms of, like, you have to study. I'll just make it a note here so that it is helpful for you guys. Okay, so different kinds of clemency are there. First of all is pardon. Pardon is what? Complete forgiveness. Okay, totally, the punishment is totally gone now. Then we have commutation. Okay, What is commutation? Reduction of punishment, matlab reduction in nature. Okay, suppose somebody has got a death penalty say it can be given as life imprisonment. Then we have remission. We just discussed remission. Remission is just reduction in sentence without changing the nature. Okay, the nature is not changed. Life imprisonment hai, suppose the years will be changed. Then we have respite. What is respite? There is a reduced sentence due to special circumstances. So only in case of special circumstances, जैसे disability or pregnancy. Okay. Last one is reprieve. Okay. Reprieve is a stay, temporary stay on execution. Okay. Suppose somebody is going to get capital punishment. So there is a temporary stay on that. Okay. The last topic is black coat syndrome. So why was it in news? Because the president referred to the term black coat syndrome, drawing parallel with the white coat hypertension. Okay, to describe the stress and anxiety experienced by citizens when interacting with the judicial system. So why was this? Because in India we have something called as the culture of adjournment. Okay, I hope that you are aware of this famous Bollywood dialogue, no, Tariq pe Tariq, Tariq pe Tariq. Okay, so we have adjournment. Okay, the cases are not concluded soon. Okay, there is always a delay. So what happens in in deciding of cases, the poor from the villages are still very anxious to approach the courts. Okay, as they feel that fighting for justice will make their lives even more difficult. So there is a parallel of this. Okay, it is called white coat syndrome, white coat hypertension. When you what happens is when you see the doctor, you feel even more hypertensed. Okay, so what is the reason for this perception? Because we have a lot of case pendency, delays, there are frequent adjournments, and the district judiciary issues, like we just discussed, the poor infrastructure of district judiciary. Okay, so very easy question, but let us do it anyway. Black coat syndrome is associated with whom? Politicians, lawyers, judges, okay, CAs, or military. Yes.
Second option, madam.
Yes, second option. Okay. So with this, we finish the judiciary part, guys. Okay. So tomorrow we will start with the minority issues and the miscellaneous topics. Okay. So thank you for watching this videos, guys. If you are liking this initiative, please like the video, subscribe to our YouTube channel. Also share this with your friends who are preparing for UPSC prelims. You can find the PDF of this current affairs in our Telegram channel. The link will be provided below. Thank you once again.